And we're on. Thanks so much for having us, Brett, and thank you everybody for appearing tonight. Looks like there's 100 people here, so the pressure's on, Nick. We got to bring our A game. So I'm Mark Saul. I'm one of the partners here at Carpenter, Hazelwood, Delgado, and Bolin, and Nick is one of our partners as well. Nick and I have been with the firm for a really long time. We love what we do. We live and sleep and breathe HOA law. So some people may not think it's as exciting as we do, but we sure do. So thanks for joining us tonight. We're really going to be focused mostly on board member duties and board meetings. So I'm kind of putting myself in your position because I've served on a nonprofit board. I've been there. And I'm kind of thinking, what would I want to know if I was serving on the board on the day-to-day? What duties do I owe the association and the membership? What's a board meeting supposed to look like? What are some of the legal challenges and practical challenges? And to Brett's point, if you have any questions this evening, go ahead and type it in the chat feature. We'll try to pick them up as we go. And if you have something at the end, we're going to try to reserve maybe 15 minutes for Q&A at the end as well. So let's go ahead and get started. Brett, if you get the next slide, please. So really, we're going to talk about some scenario-based learning. We're not just going to talk about what the law is. We're going to put yourself in some of these positions and kind of have, what would you do? If this is the board meeting, what would you do? And kind of think about it, and then we'll talk about what we would recommend. So we really want to talk about some exposure to what your duties are as a board member and conducting effective meetings. Now, there's some meetings that are going to last a couple hours, 2, 3, 4 hours. We don't love those meetings that are there 3 or 4 or 5 hours, right, Nick?
We do not. No. You know, y'all don't know that. Maybe you don't know this yet, but you're not going to be getting paid enough for a long meeting like that. So keeping them short and to the point would probably be preferable.
That's why we always joke that, that's why board members get paid the big bucks, to sit through these long meetings. But we all know you don't get paid anything. So whether you're there for an hour or 4 hours, you're making the same amount of money. So ultimately, but that's one of the main things that a board member does, is that they conduct meetings and they make decisions at meetings, even though they're making some decisions behind the scenes and their role is not just attending meetings. That's a very large part of a board member's duty. We're also going to touch on avoiding liability, both as a board member and on behalf of the association. Next slide, please, Brett. So board member duties, and I love this cartoon. I don't know if anybody can see it. My eyes aren't as good as they used to be, but if you see it there, everyone's sitting around the boardroom, and the board president presumably is welcoming everybody, and they say, we would like to welcome our newest board member, Debbie. You'll need this if you decide to walk around the community. It's a bag over her head. So unfortunately, not a lot of people are going to thank you for what you do. Okay, we know it's generally a thankless job. So Nick and I and Brett would like to be the first to thank you all for serving on your boards, right, Nick?
That is correct. I was on my board as well in my association for a while, and I don't remember getting a lot of credit for the hours I was putting in. So yes, in advance, thank you for your time and your efforts on your respective boards.
And you're not alone. Nick is a fellow board member. I serve on my neighborhood association board, and yeah, it is thankless, but we thank you for it. So what's it look like if you're serving on a board? Well, again, it's not just attending meetings. That's one of your jobs, but it's also not being just one issue. We're not just going to think about one issue and say that's what we're going to talk about every single board meeting. I had a board member years ago for a very large community of ours. We still represent them to this day. And all he cared about was house painting. He would walk around and note all of the houses in his neighborhood that he thinks needed some touch-ups. And that's all he wanted to talk about at the board meeting. Well, it was a 7-member board, I believe, and it was always 6 versus 1. They didn't want to talk about it, So it finally had to pull him aside and say, you're just one member of the board. You got to talk about some other issues, because the majority of the board doesn't want to talk about painting houses anymore. That's an important issue, I suppose, but it's not the only issue. There are another 100 issues we need to talk about. So it's not just being that kind of that one-trick pony. We want to talk about house painting. We want to talk about parking. We want to talk about speed bumps. They're all important. You can't just care about or worry about one of them. It's also important to participate and study and vote and educate yourselves. And I can tell you right now, when we have over 100 people now on this call, we're saying that there's over 100 people that care so much about serving their nonprofit board, which they volunteer to serve on, that they're sitting through this hour-long seminar, and probably others as well, to learn more and hear about what we have to say and to think about some of these issues and ask us questions. I mean, that's incredibly important. I can tell you a lot of people that volunteer say, I don't want to put in an hour a week or a month, let alone attend a late night seminar with a couple of lawyers telling us about HOA law. So we appreciate you being here and listening, but that's really part of your duty too. And participating and voting at the meetings is incredibly important. Nick, have you ever been in meetings where you'll have some people just magnanimously say, I'm going to abstain because I'm not going to vote on this? Have you been there?
Yes, unfortunately. I don't know if sometimes it's a principled stand or they haven't put in the work to become informed on an issue. But yes, unfortunately, that happens on maybe an oddly usual basis, actually.
And what is your opinion just basically on abstentions when someone wants to abstain?
Uh, I'm never a huge fan of it. To your point, if you're on the board, your job is there to make decisions on behalf of the association, and we'll get to this. But for the good of the association, an abstaining vote is really not doing either one of those things. So it's hard to say that you're really fulfilling your duties as a board member if you're not engaging in the process or not participating in votes on important issues.
I couldn't agree more. Everyone's got their pet peeves. I hate to just have editorials, but I completely agree with Nick, because if there's a reason you can't vote, like say I wasn't at the last meeting or I didn't serve on the board at the time and you're going to adopt board meeting minutes and I wasn't there, sure, abstain from that, or abstain because you have a conflict and I couldn't possibly vote on this because I'm conflicted. But if it's just because you don't want to answer your neighbors the next day when you voted yes or no, it's like congressmen and women. We're paying them. We voted for them to make decisions on our behalf. And you serve on the board it's a representative form of democracy, very similar to Congress, except you don't get paid, as we've made clear tonight. But you are elected to make those tough decisions. Okay, so that's important. And this is also important because we get the next point on the slide is that you make the decisions. Okay, unless the CCNRs say that the owners or the members make the decisions. Because we have some boards and they want to pull the audience. I'm dating myself back to like the original Who Wants to Be a Millionaire, right? But I want to pull the audience. What would you all do out in the audience today? There's 30 people out there. Well, that's why you were elected to make those decisions, right? There's certain things like CCNR amendments, special assessments perhaps, that you might need a membership vote on. If you want to do Survey Monkey or informal polls, I'm generally okay with that, but I would say be careful what you wish for, because say you poll everybody, should we put in speed humps? I say speed humps for a reason, right, Nick? Isn't that one of the biggest things where you'll have like the bride side and the groom side show up on each side, for and against them?
Yes, and I mean the reason I'm laughing is not only because my dog is making a ton of noise, but also because it actually does remind me of Who Wants to Be a Millionaire, where they're desperate to go to the audience and they get a split vote back, and it's like, well, now you've wasted a lifeline. And it's
Yeah,
kind
the
of the same thing here. Yeah, you're looking to get bailed out and not have to make a big decision. And oftentimes it falls just like any other vote across the country. It'll be 50-50 more often than not, frankly. If you're undecided, then frankly, so is the rest of the community probably.
That's a great point, Nick. I mean, either it's one of two issues that we usually see. Either comes back 50-50, that's not helpful, and you're back where you started, or it comes back like 90% in favor of speed humps, and the board, they don't want to pay for the speed bumps, they don't want the speed bumps, but now you feel like, well, if we were going to listen to people, then we may have to put in speed bumps. So it's important to hear people. We'll talk about board meetings here in a second. It's important to hear people before you make your vote. So you may say you were going to vote in favor of speed bumps, but then you listened to all of the members there with their opinion, and some people had some really good opinions, and maybe you changed your mind. That's perfectly fine. That's actually healthy. But the point is, you shouldn't just always be surveying people and say, what are the memberships? What do you want to do? That's really a board decision. Now, what is the board do on a day-to-day basis? Well, you've got a great management company, okay? You have CAD, and that's why you hired a good management company, so you wouldn't have to be self-managed, perhaps, and make all of these decisions day-to-day. Maybe pay our bills or the landscaper bills, or maybe do a walk with the landscaper on a weekly basis, or collect all of your AR, or draft all the newsletters. I mean, that's why you've got a great management company in place. So you absolutely should utilize them. Now, there's certain things that you probably shouldn't be delegating to your management company, okay? You make the high level decisions, but I call that policy. So you're gonna make your common area rules. You're gonna make the high level decisions on who to hire, as your landscaper, your law firm, etc. That's usually going to be your decision, but you're going to listen to CAD. If they're gonna say, you know what, ABC Landscaping is a great company. Carpenter Hazelwood is a great law firm. Yeah, listen to them, but those are typically your decisions. But are you gonna go out on a day-to-day basis and try to run the organization? Probably not. Again, that's why you have a management company. And along those lines, if you follow the proper channels, that will ensure efficiency, as opposed to saying, well, the board's going to talk about this, and then we're going to go to the manager, or I'm just going to go to the manager, but the board doesn't know what I'm doing. Nick, have you ever seen that, where you have everyone bombarding and nobody knows what the other person's doing, and they don't really have any organization?
Yeah, it happens again. It's not uncommon. And just to put ourselves, to use ourselves as an example, a lot of times, once the board becomes familiar with a law firm or some other vendor, all the board members will start to feel like, oh, we can reach out directly to the law firm or to the contract, to the landscaper, or whatever it may be. Problem is, if you have like 7 different people and they have 7 different opinions, seven different ideas, they'll come to us and you'll get 7 different inputs, none of them all syncing up. And that's why for us, to the point about efficiency, we will often say, okay, we will only respond to one designated representative from the board who will be the point of contact with the legal with the law firm. They'll be the legal representative or the legal liaison, whatever you want to call it, which actually goes a very long way towards efficiency. And applying that to just about the rest of the association's decisions, it's a really good policy to try to designate one person who may be sort of the point of contact for different vendors, maybe the management company, or again, the law firm or something along those lines.
I completely agree. I had a board meeting last night, and they were talking about social media, because one board member was doing his own thing on social media. Half the board liked it, half the board didn't like it. So they have to come up with a social media policy. And I said, you should have a liaison, have one person that's really charged with doing that, so you don't have everyone trying to do it at the same time. And finally, this is probably one of the most important things on the slides you'll see tonight. And we like to think everything's important. That's why we put them on our slides. But supporting the board's positions, we actually put it on 2 of our slides because it's so incredibly important. If you have a 7-member board, you'll have some 4 to 3 decisions. When I served on a nonprofit board, some of the best, most robust, and useful dialogue, not argument, dialogue and debate, were on some of the 4 to 3 votes. But that just means that you care. And that means not everybody's always in lockstep 7-0, that they always just think, yeah, whatever the other person says, and we'll just use groupthink. 7-0 votes can be great, but 4 to 3 votes can be okay too. But if you were in the minority on that 3 vote, just remember, unless you think, you're going to get sued and we got to get, legal counsel involved, it was a horrible decision, I guess there are exceptions, but for the most part, you need to support the rest of the board, because your client, just like Nick's client, my client, and Brett's client, is the homeowners association, right? It's the corporation. And for the corporate entity, it never helps that corporate entity for board members to be going to neighbors and everybody else saying, I hate the other 4 board members, they made a horrible decision, you should show up in the next meeting with your pitchforks. That doesn't help the corporation. I've never seen that help the corporation, okay? So maybe next time, if you didn't like the rest of the board, you can always campaign for other people to run for the board, but who's on the board is on the board, and we should try to support each other the best that we can. Next slide, please. Brett, are there any questions so far? I'm not able to see any on my screen, but I'd be happy to answer any of them.
There have been a couple of questions. The first question is, our board has some confusion about Arizona's open meeting law for HOAs. Can 3 board members get together and talk about an HOA matter without calling a meeting? We know they can't take a formal action without a duly noticed meeting.
It's a great question, and it's on one of the other slides, but I'm not going to make you wait for the slow reveal here. So it depends on how many board members you have. So say if you have a 5-member board or less, then your quorum is probably going to be a majority of that, which would be 3, okay? So if you have a majority of the board present, whether it's on the telephone or in person, and you're talking about board business, that's a board meeting. Now, years ago, people used to call them workshops. They'd say, well, Mark, we're not making any decisions on those. Why do we really need to have an open meeting and notice it? We're not really making any decisions. Well, Nick, the law changed on that years ago, right, to make that clear?
That is correct. And correct. If there's one point that the legislature, when they are drafting laws that affect community associations, if there's one thing that I feel like they've been pretty clear about, it is that they want transparency and they want their open meeting laws followed. And any ambiguity or any suggestion that there's a gray area in that regard, they want it I guess, decided upon in favor of transparency and having all association business, whether it's a discussion, brief conversation, whatever it is, if it's the form of the board discussing association business, they wanted to have an open meeting. They've made that clearer and clearer throughout the years here.
And to Nick's point, it's if you're a planned community, it's in ARS 33-1804, and I want to say it's like subsection E. The legislature, which is strange, went out of its way to adopt a separate paragraph to specifically say what Nick is saying. And it really says, when in doubt, you need to have an open meeting, right? I mean, you need to be transparent. That's strange for the legislature to say that. So yeah, you can't anymore get away with this. Well, it's just a work session. It's not actually a formal meeting because we're not taking any action. You still need to have it properly noticed and have it open to the membership. And I see that in the quote, if there is a quorum of the board, it must be noticed ARS 33-1804. Exactly. Brett, do we have any other questions so far?
There's actually two more questions. How often do boards put issues up for a full member referendum? And then does Arizona's law state that you have to announce the reason for your abstention?
Okay, so full member referendum, I would just state that as a membership vote. The only time you have to go out for a membership vote is when your CCNR's bylaws or articles require it, which is generally CCNR amendments, quite often special assessments, sometimes conveying your real property. Nick, can you think of anything else that usually requires a membership vote?
Not off the top of my head. I was actually just recently dealing with one where they had to approve a budget, and that was kind of a mess. But to your point, I think you've nailed kind of the more typical ones. I'm sure some documents have a few obscure or more uncommon examples, but I think you've nailed sort of the typical ones.
Yeah, so that's really about all, but remember, it's all document specific. Unless you're a condominium, condominiums require a membership vote of at least 2/3 to amend your CCNRs at a minimum. But planned communities don't even have that. So it's all document specific. And then the final question about abstentions. Nick, I'm not aware of anything in Arizona law with respect to abstentions or having to state what your reason is.
No, but on a practical basis, I can tell you that if you try to do it at a board meeting too often, eventually the members are going to ask you for your reason and why you're not participating. Just because that's practical and that's boots on the ground experience for myself. So not that I was doing it, but we had somebody on my board who used to try it all the time. And eventually the membership was like, hey, if you're a board member, why aren't you participate? Why aren't you engaging in the voting process? So yeah. But yeah, as far as what the law requires, I'm not aware.
I agree with you, Nick. It's like, practically, yeah, you're probably gonna have to, answer to the folks that elected you, but legally speaking, we're not aware of any duty to announce. Just like if you vote yes or no on a motion, you don't have to explain yourself. Same with an abstention. All right. Fiduciary duty to owe to the association. So what is a fiduciary? Well, think of someone that handles your money. Think of your banker. Think of a trustee. Think of somebody that owes that fiduciary relationship to you and owes you a heightened duty. Now, it's important to note a board does not owe the membership of the corporation, i.e. the homeowners, a fiduciary duty. You owe the members a different duty to treat them reasonably, okay? You don't owe that same duty to the members that you owe the corporation. But what do you owe to the corporation? What is a fiduciary duty? It's really three things. It's the duty of good faith, the duty of care, and the duty of loyalty. So what's the duty of good faith? Well, that's subjective. Say Nick's serving on a board, and let's talk about raising assessments, okay? Because that's always a hot topic. And in Nick's heart of hearts, he says, you know what, Nick Nagami, I think raising assessments is in the best interest of this association. I'm going to vote in favor of this. I think that's the right decision. Okay, 1 for 1. He satisfied that first prong of the 3 prongs for the fiduciary duty. Next up, duty of care. What's the duty of care? What would a reasonably prudent board member do under the same or similar circumstances? That's usually the first thing you learn in law school in torts class, year 1. It's the reasonable person standard. So Nick thinks, well, what would that reasonably prudent person do? Well, there isn't such a person, but in theory, the objective criteria. What would a reasonable board member do? Well, they'd probably raise assessments. Okay, 2 for 2 he passed. The third one I think is the most important, and that's the duty of loyalty. Whose interest am I really acting in? And that's why I love talking about assessments, okay? Because it's never going to be in any of the attendees' issues tonight, 111 of you, it's never going to be in your personal interest to raise assessments or raise taxes. If you're anything like me, you want to keep that money in your pocket, not the association's pocket. That means you're economically rational, and that's okay. But when you serve on a board of directors, whose interest needs to come first, Nick?
The associations.
There you go. You passed the pop quiz. So it's the corporation's interest that we take first. So Nick, in his mind, he says, internally, subjectively, raising assessments. Reasonable person raising assessments. Duty of loyalty, I don't want to raise assessments because it hurts me, but it helps the corporation. I'm going to vote in favor of it. He passed that test on the fiduciary duty. So what has he done with the duty? He's discharged it. You're anything like me, when you get home and your husband or wife asks you to take out the trash, you want to discharge that duty. You want to get that done so you can go sit on the couch and watch some TV. It's the same thing here. We want to get rid of these duties so we don't have to worry about them. And that's what you're doing with every single decision that you're making, okay? Well, what if we make a mistake, all right? What if we try to do all the right things, but it turned out we made the wrong decision, all right? That's okay. Everyone makes mistakes, okay? It's just like the practice of law. We make mistakes too. Nobody's perfect. But when does your directors and officers insurance kick in? Well, more often than not, it will. Unless something really goes wrong, or if you don't have a policy that will protect what happened, that's generally going to kick in. So if you're acting in good faith and you're abiding by the duty of care and duty of loyalty, you shouldn't have any issues. Even if you end up getting sued personally or the corporation gets sued, that's why you have good directors and officers insurance, because anybody can sue for any reason, any day of the week. All right. Next slide, please. Brett, do you have any questions before we get on to the next slide? All right. So we're talking a little bit more about the duty of loyalty, and you can scroll through some of these more quickly. This is both objective and subjective. Do I think that I'm being loyal to the corporation? And would someone else think that as well? But ultimately, it's got to be in the best interest of the corporation. And if that coincides with your best interests, that's great. But if it doesn't, you have to put the corporation's interests first. And I know it's difficult. Like I said, Nick and I have served on nonprofit boards, and it's difficult to make decisions that are not in your own best interest. But that's really the higher duty that's owed to the corporation than really you owe yourself sometimes. And you see it's in bold on this slide for a reason. This includes keeping board information and legal opinions confidential. Now, I will tell you how important, I think this is personally and professionally. I'm a lawyer, Nick's a lawyer, we take confidentiality very seriously. I've had situations even when I'd come home and I don't tell my wife things about what happened at work or what happened when I served on my nonprofit board. And she has to find out later and then ask me why I didn't say anything, because I take that very seriously. Nick, I think you do as well, right? We keep a lot of things close to the vest.
I do too. I feel the exact same way about keeping it, placing a lot of importance on it. And frankly, we might get into this later. I can't really recall if we get into this, but there becomes sort of a risk reward thing too, where you are tasked with this responsibility. You do have this duty to the corporation. It's very real, and a lot of the things that you're being asked to keep confidential or keep close to the vest are things that could ultimately lead to some very serious liability for the association. And if you are not honoring your duty or upholding your duty to the association with regards to that information, it's one of the rare instances where you could actually face personal liability for breaching that duty to the association. I'm actually going through this in a case right now where a board member has decided to go a little bit rogue. He's trying to disclose some information that is subject to the attorney-client privilege that belongs to the corporation. And he may actually wind up facing some personal liability for making that decision on his own behalf. So I would say that when you are considering, whether or not to keep certain delicate or sensitive information, confidential, I would definitely weigh the risk reward of it all. And ultimately, I would say that it's going to weigh out in favor of going ahead and playing that close to the vest. And to Mark's point, letting people find out about it in the natural course of business.
Yeah, with great power comes great responsibility, just like Nick's saying. It's true, and I'm going to throw out all the cliches here, Nick. Loose lips sink ships. Say that 10 times fast, but it's true. We have cliches for a reason, and I've had cases like that where as soon as I tell a board member something, I know some board members are going to go and tell everybody about that, no matter what I tell them. And like Nick said, you could have personal liability if you do that. That's not taking the duty of loyalty seriously at all. It's like, oh, you'll never guess what Mark and Nick told us, and Mrs. Johnson down the street is going to sue us, and if she knows this, she'll have a really good case. We don't want Mrs. Johnson to know why we have a bad case, okay? That doesn't help the corporation. So it's incredibly important. Keep executive session in executive session. You need to talk to somebody, talk to your manager at CAD, talk to another board member, but less than a quorum. And don't talk to your spouse, don't talk to your neighbors, don't talk to your friends, don't talk to your children. Okay, what happens in exec stays in executive session. What about conflicts of interest? Nick, what exactly is a conflict of interest when it comes to voting on a board of directors for a homeowners association?
Well, usually it means there's a decision in front of the board that you or a spouse or really, I mean, I would probably extend it out to just about anybody to whom you are personally connected, has possibility to realize a financial gain from the decision from your based on your vote. And so the community association statutes that issued here are very specific about what to do in those situations. And they basically call, oh, sorry, I didn't mean to jump ahead. You asked me one question. I didn't mean to sort of keep running with it there.
No, but you're exactly right. I mean, if there's a financial gain to be had, should we be voting on that issue? Should we declare a conflict? So go ahead and the next slide, Brett. But that's just it. When it comes to conflicts of interest, we need to take it seriously. I like the best example, Nick, that I always use is, well, my brother owns a landscaping company. Okay, right. Family member, he makes a lot of money off of landscaping, I suppose. And say if I want to use him for the board, for the association's business, that's perfectly fine. If he's the best landscaper in town, he can work for the association. But what should I do? Because I'm his brother, I need to announce that I have a conflict. My brother is the owner of ABC Landscaping. I think they do great work, but I'm not going to be involved. The Nonprofit Corporation Act says you should recuse yourself. The Planned Community Act and Condo Act don't require recusal, but it's still a best practice. But at a minimum, you have to announce your conflict. Otherwise, the whole contract could be declared void if you don't declare your conflict before you have that conversation. Anything to add to that, Nick?
No, except for the fact that that declaration of a conflict needs to occur in an open meeting of the board, which frankly, I would say that the entire discussion should have already been in an open meeting. But just to be sure, the declaration of the conflict does need to be in an open meeting so that the members can actually hear your declaration.
That's a great point. So safe harbor and business judgment. Years ago, the courts used to care about board's discretion, and they kind of basically assumed that the board was doing the right thing unless somebody proved otherwise. That's changed over time. For about the last 10 to 15 years, we don't really have that standard anymore. It's really, are you acting reasonably when you have discretionary decisions? And even if we thought that the CCNR said one thing, the judge is going to have the last ruling and the last laugh sometimes, unfortunately, on what he thinks or she thinks the CCNRs really mean. But how do we make sure we're doing the right thing? It's listening to the experts. Again, that's why you have a great management company in CADN. Listen to them. If you have a question, ask them. If they don't know the answer, they will call us perhaps. They'll call your accountants. They will call your landscapers. They'll call your engineers, and they'll find an expert that has the answer to that question. Because I will tell you, one of the board members, this is no offense to attorneys, we're attorneys, but one of the board members may have been an attorney in Florida 30 years ago that practiced criminal defense law, okay? I'm sorry, but that person is not going to be qualified to provide you Arizona HOA law guidance, okay? That's not someone you can look at and say, well, they're an expert in this field, we're going to listen to them. No, ask us. Lawyers know everything, I say just ask us. But at some point, you're not going to have that get out of jail free card if you don't listen to a true expert in the business. That's what we call safe harbor. That's as close as you're going to get to a get out of jail free card serving on a nonprofit board. That means if you're sued individually by the corporation and someone says, why'd you make this decision? Nick and Mark told me to do it. And you slide over that opinion, you waive the privilege, and you protect yourself. Now, say Mark and Nick had a bad day. Say they just got it wrong. Again, it's the practice of law. It doesn't matter. That's the beauty of it. If you relied on it and had a reason to rely on it because we're experts in our field, you will be protected. So when in doubt, get an opinion from an expert and stand behind it. Ultimately, what if we made bad decisions still, but we tried our best? Well, the good news is Arizona law is on your side, okay? You're not just gonna be exposed to liability for any decision you make. You've gotta do something, I gotta say, pretty bad to have personal exposure. And in our careers, I think I can speak for both of us, Nick, we haven't had many cases where we've seen personal exposure for board members. It's usually acting well outside their scope, doing something horrible, doing something fraudulent, criminal, etc. It's not easy to have liability, but you still got to try to do the right thing and be reasonable. Next slide, Brett. I'm not going to go through all of these. If you want to just go back to the last one, there's one more back, I think. All right. We're not going to go through all these. We're not really going to go through any of them, but I just wanted to let everybody know, if you haven't served on the board that long, I mean, Nick and I could literally talk 15 hours if we talked about all of these things. And I'm not going to subject to you guys listening to us for 15 hours. But fair housing, satellite dishes, the purple gazebo next door, neighbor-to-neighbor disputes, insurance claims, marijuana use in common areas, short-term rentals, vendor contracts. I mean, I didn't even mention all of them on this slide. And it took me a while. I mean, the list goes on and on and on. So this is when we talked about you can't be a one-trick pony and just care about one thing. You could have any of these issues come up in the same year and probably more. I only listed what I could come up with in a few minutes off the top of my head because we do this every day. So for anyone that hasn't served on the board before and they come onto it and they say, whoa, I had no idea that we had these many things in front of us. So just a smattering of some of the things that you might see. Nick, I'm sure you could come up with another 10 right off the top of your head.
I could, and just because there's 110 people on here, I do want to impress upon everybody that this seems like an intimidating list, and these seem like really big issues, and we're using the word liability and everything a lot tonight. Just know that when it all boils down to it, and boots on the ground, you're dealing with these issues. They're not as intimidating as they seem. And your manager will have seen every single one of these 1,000 times over, just like we have. They'll be able to guide you through them. There's nothing that they haven't seen, or we haven't seen, or anybody else on the team that's supporting the association hasn't seen. So I kind of wanted to jump in because I remember when I was first serving on my board and I was given a list kind of like this, and I was like, this is a very daunting undertaking. I'm not really sure I'm comfortable with it. Just you're not the first one to feel that way, but trust me, each one of these can be explained by a good manager or a good attorney or a good accountant, whatever it may be, in a few minutes, and you'll be pretty up to speed on what you'll need to do and how you'll need to approach the individual subjects.
That's a great point, Nick. I mean, everyone's eyes are probably like this, when you first start out. What did I get myself into, right? But to Nick's point, between Cadden and Carpenter Hazelwood plus your other vendors, there probably isn't anything or pretty much nothing that we haven't seen together. Okay, Cadden's been doing this a long time. We've been doing this a long time. You probably have a lot of other good vendors involved as well. So rely on them and use all of your vendors when you need to. All right, go ahead to the next slide. All right, this is a what would you do? So if anyone wants to put in any chat, and we'll get some board involvement here. So it's open session. That one owner, AKA the heckler, they're present and they're ready to heckle you. Well, as usual, they're disrupting the meeting. What do? I probably would have this memorized, but not quite. If you go ahead and roll it to the next ones, Brett. A, do you just ignore the owner? B, and this is my favorite one, engage or argue with the owner. Because Nick, doesn't that always work? A good old-fashioned argument?
In my experience, yeah.
C, allow the owner 2 to 3 minutes to speak. D, allow the owner unlimited time. E, just adjourn the meeting and say we're done here. Or F, I do something else and I'm willing to share. We'll give everyone, maybe 30 seconds to type something in here. While you're typing, I can just tell you, A is a bad idea, and B is probably the worst. I will tell you, you don't have to engage with owners. And I'm not saying if someone asks a question like, hey, Nick, hey Mark, hey Brett, when's the next board meeting? I didn't have it on my calendar. Answer them. You don't have to say, sir, you're out of order. At some point, that's not reasonable. But if they just want to argue with you forever about what decision you made, why you shouldn't make, that decision, and this isn't on the agenda, but I'm going to talk about it for 20 minutes. No, you don't have to deal with that. You don't have to engage people. You can simply say, sir, ma'am, thank you for your question, or thank you for your comment, and you move on. Okay, you don't have to engage. Brett, do you have any questions or any comments on this one? On what would you do?
So most of the people answered C. A lot of them said, but this time limit should be decided before the meeting. One of them asked, well, is muting an option as we're doing virtual meetings?
You have some smart homeowners on or board members on the line. I didn't even think about that, Nick, but you're right. I mean, the 2 to 3 minutes, you shouldn't come up with that on the fly, right, Nick? I mean, that should be something before that you kind of adopt.
Correct. Yeah, no, I was not prepared for that. That was a pretty experienced answer. That's pretty
Yeah,
good.
and they're right. I mean, you shouldn't just on the fly say, hey, how long should we give the heckler? No, it should be going in. You should know that. And can you mute people? Yeah, I think you can. After a couple, I just told a manager that today. I said, if you have problems with them, mute them. They say, oh, we've done that before. I mean, I wouldn't start with them on mute when everybody else isn't on mute. That might not be reasonable, and I wouldn't kick them out of the meeting, at least not immediately. But I would say C is the best answer. But to your board member's point, they're exactly right. Have that decided at a prior meeting when you talk about your codes of conduct, perhaps, on what's reasonable. And we think 2 to 3 minutes is reasonable. Adjourning the meeting, that's sometimes necessary. It's not as necessary with Zoom because you can kick them out or you can mute them. But in an in-person meeting, we've had some where we have to have, on-site security guard. I've seen people arrested at meetings. We've been threatened at meetings. I think I can speak for both of us and probably a lot of managers for CADN as well. And there's some tough people out there. But ultimately, we like C, allow people a reasonable time to speak, and then adjourn the meeting if necessary. And mute people when you can. Anything else to add to that, Nick?
Not really. I would just, and maybe this is a point I can make later, but I'll just say it now because it's on my mind. One of the things that, we try to impress upon people and that kind of gets lost is, homeowners association has a certain reputation out there, but keep in mind that this is still a nonprofit corporation. And these board meetings are there for the board to actually get together and conduct board business. It's not the time for people to come and be obnoxious to their neighbors who happen to be on the board or to raise a scene just for some attention or whatever it is. You are actually there conducting business and making decisions that affect a lot of people and that concern a lot of money and a lot of really important property. So it's your meeting. You're there to conduct business. You're volunteers. You don't need to be there for 5 hours, letting people just kind of, have their, tantrum, for lack of a better word. So, keep in mind when you're making decisions like this, it's what you need to do in order to keep the meeting going, to be productive, to be efficient, and to get out of there at a reasonable time, but also make sure you get all of your business done. That's something that people kind of gets lost, and it's sort of in the name a little bit. People get confused, but just remember, you're on the board of directors for a corporation, so you're there to conduct business. Do what you have to do to conduct business. Be reasonable about it. But for sure, if somebody's there disrupting things and being obnoxious and infringing on our ability to conduct business and make decisions, I mean, absolutely, you can mute them. I mean, you can kick them out. It's one of the nice things about Zoom meetings, frankly, is it's a lot easier to take actions like that as opposed to in person, where it's a little more confrontational. So
that's
a little rant about board meetings. Sorry.
No, it's a great point. I mean, we're passionate about this. I think everyone can see that, but it's like Nick said, it's all in the title. It's a board meeting. It's not an ice cream social for the membership. You know what is? An ice cream social for the membership, but this isn't that. So if it's a membership gathering or an annual picnic, great. That's the time for owners to just get together. This is the time for board to conduct business. Okay, next slide, please, Brett. All right, you can just roll through some of these. So we talked about this a little bit before, so we'll be faster now. But if it's a quorum that meets to discuss association business, including workshops, call them whatever you want. If you're a quorum and you're discussing board business, it's a meeting. Now, what if 3 of the 5 of you are best friends and you get together to watch the Super Bowl every year? You get together for a happy hour every Thursday night. That's perfectly fine. Keep doing that. Perception might be a problem if someone sees you going 3 people into the same place every week at the same time. But if you're not talking about association business, it's not a board meeting. That's perfectly fine. But this is key because I know this is one of the board members that you asked a question earlier. It's a great question. Well, what if we don't vote? We're just having a workshop. Again, it's still a board meeting. Law changed years ago to make that absolutely clear. What do we need to do? Rely on CADN for this. You just let CADN know when you want to have these meetings. It's a minimum notice requirement of 48 hours, conspicuous posting, put on the clubhouse, put it on your website, put in your newsletter, any way that everyone can see it, at least 48 hours. Make the agenda available at the meeting. You don't have to make the agenda available a week before or upon demand. It just needs to be made available at the meeting. And again, I told you I was going to tell you this twice, and I didn't lie to you. Support the board's positions at the end of the board meetings. Anything to add to that, Nick?
No, I think you nailed this one, boss.
All right, appreciate that. Flattery will get you everywhere. All right, next slide, please, Brett. And we have talked about a little of this before as well. You know, when people can speak, you know, you don't have to have an open forum for homeowners just to gripe or talk about non-agenda items. I will tell you, what do you think, Nick? Probably 99% of our clients have open homeowner forum.
I'd say that 99% of them start with it, and that number tapers down by the end of a board's term or an individual board member's term on a board.
That's a good point. I would say Arizona law doesn't strictly require just a straight homeowner forum, but what does Arizona law require? At a minimum, you need to allow members to speak for a reasonable amount of time before you make the decision. Okay, so we'll talk about this a little bit later with Robert's rules, but it's going to be motion, seconded, board discussion, homeowner discussion, all in favor, rinse, repeat. Okay, make it that simple. Unless you have to follow some other version of Robert's rules, which we'll talk about soon, I would say make it simple. Motion, second, board discussion, homeowner discussion, all in favor, and just follow that. And that will help you have tighter, more quick meetings as well. And you won't be there 4 or 5 hours, because I've been to some board meetings, including some of my own, where people want to talk for a half an hour before there's a motion on the table. Well, if you have a question for your manager or you have some other questions before you can even make a motion, perfectly fine. But really, you need to read some of your board packet usually beforehand, figure out what the issue is, and be ready to discuss. So that's where you get that motion right on the table, and then you actually have something to discuss. All right. Just know members can record meetings. I was at a meeting a couple days ago in person, and someone was recording it with their iPhone just like this the whole time and made it clear he was recording it. Can't stop that unless we record them ourselves and provide an unabridged version, which we don't always recommend. So just know people can record your meetings. They can express their concerns, but you're not obligated. They can talk for 3 minutes about how they hate you and the manager and us and the landscaper. You can say, thank you for your comments. Moving on, okay? Feel free to move on. All right, speaking of moving on, let's go to the next slide, Brett. All right, we've talked about meetings a lot tonight, but we haven't actually talked about the 2 types of meetings. And those are closed meetings or executive meetings and open meetings. I think I can probably remember all of these 5 things, but we can run through them on the slides, Brett. So when can we meet in executive session? Before we talk about when can we meet, it must be clear that you don't have to ever meet in executive session. Okay, you could do everything in open if you wanted to. Would I recommend it? Absolutely not, because the first 2 things are involving our firm usually, legal advice from an attorney or pending or contemplated litigation. Why would you want to tell anyone else about lawsuits you're handling in our strategy in open session? You don't. What if you have personal health or financial information of an owner or an employee? Say Mrs. Jones has cancer and she can't pay her assessments and she wants you on a payment plan. Let's talk about that in an executive session. Let's say, you know what? Mark wasn't on his best last night at that meeting, and we want to talk about a change of attorneys. We want to get Nick on board. You can talk about that in an executive session. That's perfectly fine. What if an owner wants to appeal their violation, or they put up a purple gazebo and you said no and they want to appeal it? You can do that in an executive session, unless the owner wants to grandstand. Let's be honest, right? And wants to do it in an open session, you can do it in exec. Nick, do you still have to provide notice to members of executive session?
You do. You do. Even though they won't be in attendance, they still have to know what's happening.
And you'll see again, confidentiality. We think it's so important. We listed it twice in our slides tonight. Keep it confidential if it happens in exec, even if it didn't come out of our mouths, but it was still an executive session, keep it there. All right, next slide, Brett. Emergency board meetings. I like to say fire, flood, or blood. Do you have any other good examples, Nick, of when it's actually an emergency?
Not better than that.
Not as much fun, and they don't rhyme as much. But
no.
The real test, though, is can it wait 48 hours? And if it can wait 48 hours, it's not an emergency, notice it. If it can't, say our clubhouse just flooded or it's on fire right now, get a hose. You don't have to wait 48 hours to have a meeting and say, can we put out the fire? It sounds ridiculous, but I have a lot of clients that say, oh, well, it's an emergency meeting. I said, is it? What are you talking about? Well, the landscapers haven't been doing a great job. It's probably not an emergency, unless the landscapers burned down your clubhouse, and that's another issue we're going to have to discuss. But if you have an emergency meeting, fine if you need to, but at the next meeting, you're going to have to read into the minutes why you had to have that emergency meeting and what happened at the meeting. All right, next slide, Brett. All right, we've talked about Robert's rules a little. My editorial, I'm sorry if we have any parliamentarians on the phone, but I say less is more. Some of your CCNRs or bylaws or articles may require Robert's rules. Even if that's the case, you can usually use a simplified version of Robert's rules for the most part. But again, if you just remember motion, second, board discussion, homeowner discussion, all in favor, that's really what you need to know. Occasionally, you might have to pop open Robert's rules, but what I don't usually like is when my client could have made 5 decisions, but they spent the last half hour talking about process instead of just making the decisions, and they're elevating form over substance at times. Nick, what's your idea about minutes? What to put in, what to leave out?
I would say that to your point earlier, a little bit less is more. I mean, put enough in there so that we can look back later and know what actions were taken, what the agenda items were, that they were followed, that kind of thing. But as far as the nitty gritty and the sort of, if you call it dicta, or just sort of the random discussion that happens with regards to each individual decision, I would recommend leaving that out. There's a lot of reasons, and frankly, we go into it a lot, but the discussions themselves are not pertinent to what the reason for the minutes is, which is we need to be able to know what happened at the meeting, what decisions were made. That can be documented very easily without having a lot of, and then John said this, and then, Robert said that back to him, and then, and then Mark jumped in and said this, and ultimately it's decided that, yes, we're going with that landscape.
I completely agree. Keep it simple, right? What was the action taken? Who was there? When was it? Who was present? And what was the motion? Did it pass? Move on. Brief discussion at most. All right, next slide, please, Brett. So board meeting tips, and we've talked about some of these. The homeowner forums, do you have to do them? Probably not, unless your governing documents provide. Now, I will say most of our clients do homeowner forum at the end. Okay, and there's a reason for that, because that means you can get your board business done first, and then you can do homeowner forum. I will say the speed bump board meeting I was at a few years ago for a large client, I said, manager, please move this up to the front. We need to be done with this. We got done with it. It was a nasty 20 minutes, but you know what? 80% of the people left once we were done, and then we could get back to business rather than having their pitchforks ready to go and yelling the whole time we were doing the other business. So really figure out what works best for your own community, and may depend on what the issues of the day are. Agenda items. I hear this all the time. Well, we're stuck with the agenda. You can't add to the agenda, but if you've already posted it and you can't add anything now. No, you can. It's the board prerogative, but it's the board's prerogative. If a majority of the board doesn't want to talk about painting houses, you don't. If a majority does, go ahead and add it to the agenda. What if a homeowner says, Nick, what do you think when a homeowner jumps out and says, I want this on the agenda? What do you say?
I kind of take that same approach you did last time. I say, thank you for your input. Maybe we can make it to the next board meeting. This board meeting is already set.
Perfect. I even say run for the board if you want to set the agenda, buddy. I'm more callous than you are, I guess. A little more crass. Timed agendas, especially for executive session, timed agendas can work. Use them when necessary. And then finally, this is a little bit of a plug, but hey, we're shameless. Invite your favorite attorney. Hopefully it's us, but if it's not, make us the bad guy. Okay, because a lot of times I'll have our boards, they just don't want to be the bad guy, and they don't want to make the hard decisions. And we gave you the advice. We're happy to stand behind it. Have us at the meetings, and we can explain it. I've said a lot of times, blame the guy in the suit. Blame me. Don't blame this board. I did that 2 weeks ago. We'll take bullets for you. Figuratively, literally, I don't know. Figurative at least though. So use us when you need us. Next slide, please, Brett. We'll be simple about committee meetings. Treat them like board meetings unless they're not regularly scheduled. So if your architectural review committee meets the third Tuesday at 6 p.m. at Ron's house, and that's what always happens, that's regularly scheduled. Notice it, have it open to the members who want to attend. If you meet whenever Ron feels like it and he calls the arc together like Batman, he puts the signal out, you all come to his house, you don't have to notice that. You don't have to let members in. That's not regularly scheduled. All right, next slide, please, Brett. All right, here's an important one. We'll get through it fairly quickly, though, so I want to have some more time for questions. Be careful with emails, okay? If you have business to conduct it during an open session. Like Nick said, the legislators made it clear. We have to be transparent. I see the more and more emails that are used, the more legislation we will have this in the future. Mark my words, within the next 10 years, we will probably have more legislation on what you can and can't do outside of a board meeting. If you need to use unanimous written consent, where everyone signs an electronic signature like an email and says, yes, I consent, and everyone does it, you can. The Nonprofit Corporation Act still allows that, all right? Use it sparingly, though. If it can wait for a board meeting, put it on the agenda, talk about it at the board meeting. If you're going to email, use it sparingly and use an official email account, at abchoa.org. Don't just use your own, Mark Saul at carpenterhazelwood.com or, yahoo.com. Use an official board email. So if and when you're ever subpoenaed, you don't have to have some plaintiff's attorney going through all of your personal emails. That's not fun. Finally on this, be careful with social media. I was just on a call last night with a board. I had told you this earlier. It was about social media, okay? Use a liaison, adopt a social media policy. Less is more, right, Nick?
Correct.
Don't feel you need to, see, just like you said, correct. Don't feel like you've got to go on next door and explain all your decisions. You know what you can tell them, if anything? Come to the next meeting. We'd love to have you. Okay, next up, Brett. Thank you. It's the most important part. If we haven't thanked you all enough, we really appreciate you being here. We have some time for questions, maybe 5-10 minutes, if there's any questions that we've missed, and we're here to answer them. And they don't even have to be questions we talked about tonight. Anything else, we're here for you.
All right, so there are a couple of questions. The first one is D&O insurance. Under Arizona law, can the HOA pay the deductible?
Can the HOA pay the deductible for D&O insurance? Absolutely, and the HOA should pay the deductible. They should pay both the premiums and the deductible for HOA claims. If D&O picks it up, then that's the association's carrier, and that's the association's policy. So absolutely, the association should be paying for that. I probably want maybe offline if the participant wants to shoot me an email or ask me that offline if they have any specific questions. But generally speaking, that's what I've seen, I think, happen every time. The association pays for it, and that's part of the indemnity obligation as well.
All right, the next question is a few citations to ARS regarding conflict of interest in the planned community statute would be appreciated.
Absolutely. I'll get those for you. You want to move it on the next one, and I'll get those for you quickly.
Okay. Do my duties end when my service as a director ends? If so, then can I reveal confidential information after my term is over?
I would highly recommend against that, because one, depending on the insurance coverage, you may or may not have coverage after the fact, okay? You may, but you may not. Depends on your policy, number one. Number two, no, it just doesn't just immediately end. Just like if the President of the United States was sworn to secrecy on certain things, they're not supposed to, when they're out, day one, tell us about the UFOs, okay? It's the same thing for serving on a board. If you learned attorney-client privilege information, you should die with that information. That's not something that you should disclose or use against a corporation, because in that way, that duty, I've taken the position, I don't know if you would disagree with me, Nick, that's really a continuing duty. Going forward, no, but what you learned, so if you have executive session minutes and a bunch of legal opinions, don't go sharing that, because that continues. Nick, what do you have to add on that?
I can tell you that I just litigated this very issue at a Department of Real Estate hearing, and the judge immediately, the petitioner, the person who had brought the claim against the association, was a former board member, and he wanted to use a letter that he had obtained from the association's legal counsel regarding the matter that we were litigating. He wanted to submit it as evidence, and we jumped on it right away and said, no, that's privileged information. That privilege belongs to the association, so that's an association document that you are not entitled to disclose in this proceeding. And the judge immediately shot it down and said, yeah, that's 100% true. That's not your document to disclose. I'm not going to be party to your breaching that privilege, so I'm not going to allow that to come into this proceeding. And the board member made the same argument. He said, look, this isn't my personal, these are my personal files now. I was a board member, but we argued and the judge agreed that no, that privilege continues. It still belongs to the association. You don't have the right to break it on your own. That needs to be an association decision, if ever.
Great point, Nick. Yeah, I'm glad you just litigated that issue too. So the judge completely agrees with us on that point. It doesn't just go away overnight because you're not on the board anymore.
Yeah.
That's a great question. I got a citation for you, Brett. It's 33-1811 in the Planned Communities Act. with respect to conflicts. I don't have the Nonprofit Act off the top of my head, and there is a slight conflict between the two, but ultimately, Arizona law generally tells us the stricter and the more specific statute will apply. In this case, it's the Planned Communities Act. So 33-1811 is the real statute that the board members would want to look at. What other questions are you seeing, Brett?
The next question is, confidential info and open meeting transparency seems to be in conflict. How do you navigate the conflict?
Now, that's a great question. So I would say, as long as you're doing an executive session, what you're supposed to be, okay? It's those 5 different things. There's no conflict at all. It all stays in executive session. And you know what? The legislature has approved that because they came up with the legislation, and judges will approve that, and nothing else. Like Nick was just talking about that judge. Most judges are attorneys, okay? So they get what confidential information is. So as long as you're doing what you're supposed to be doing in executive session, there's no conflict at all. Now, if you're doing things in executive session that you're not supposed to be doing, that's a problem. Or if you're doing things behind closed doors in no meeting at all, that's a problem. So transparency is all about what should be talked about in open session, talking about it in open session. That's a great question. We've been talking a lot about transparency, but confidentiality, that's like half of the presentation. So that's a great question, but we can pretty easily balance them if you're following Arizona law in that respect.
Can board members vote on enforcement of rules against themselves?
Okay, so can a board member vote against? Okay, so I've had this happen a couple of months ago where a board member had a violation, and she sat in, she talked about it, she voted on it, shamelessly. The Planned Communities Act would allow that if she disclosed her conflict, because it's her financial interest, right, Nick? I mean, it's her fine.
That is correct. Now, again, yeah. Oh.
Go ahead.
Oh, no, sorry. I was just going to reiterate my earlier point. She's going to have to disclose that conflict in an open meeting to explain to other members why she is in this unique position and why she's still going to exercise this right to do it. So there is some accountability, but sorry, that was just I wanted to reiterate that point.
You're right. Is it a good idea? Absolutely not. I wouldn't recommend it, but legally speaking, could they do it once they disclose the conflict? Sure, unless the governing documents address it, which generally they wouldn't. Good question.
Can the president of an HOA board take action engaging an attorney to write a threatening letter to a business, regardless of the reason, without the board's knowledge or authorization?
That's a very specific question. That may be one you might want to ask us offline, because it's fact specific, and it depends generally what the board member, what authority they have. Sometimes board presidents have a lot of authority just from the bylaws. Sometimes it's given to them by a board resolution. Some board presidents are very active, and they're the ones that call the attorneys, that call the landscapers, that do a lot of the deals, and that's okay. Sometimes it's not. So that's really fact specific. We'd have to probably answer that offline, and maybe you want to probably talk to the entire board about that so everyone's on the same page. Yeah.
What are selective enforcement?
You want to explain what is selective enforcement, Nick? We've had a lot of those cases.
Sorry, what was that last? What was the last thing you said there, Brett?
What are selective enforcement claims? So on one of the slides that you had, that one that had a whole bunch of reasons why you would have that list, that was one of the ones, and they just were curious what selective enforcement claims are.
Gotcha. That's just where a board enforces certain restrictions against some owners, but not against others. And usually the allegation will be, oh, well, is that, that person's a friend of the board or something, so they're not enforcing against them. Oh, but, they don't know that person, so they're enforcing, for instance, Bill and Ted, they both have a purple house, but, Bill is friends with the board, Ted isn't. So the board says, Ted, change the color of your house, Bill, you're fine. That's selectively enforcing. It's actually pretty, yeah. But it comes up all the time. I'm sure you'll come across, you'll hear allegations of it, because obviously each individual situation is very fact specific, as Mark said. So sometimes there will be a decision to make an enforcement action here that may not make sense elsewhere. So I'm sure a good number of people on this call will get accused of selective enforcement at some point, but just follow your governing documents, follow the advice of management, of council, and you'll be fine. But you'll definitely hear that term come up a lot.
Are votes of the board secret, or does membership need to know who voted yay or nay?
Well, that's wow, that is an interesting one. I don't know if I've ever been asked that question. Obviously, executive session, people aren't going to know. In an open session, I've seen some where they have, secret votes on, electing officers, perhaps, and drawing lots, or not drawing lots, writing it down. And I don't know that that's an issue. Again, it's a transparency issue. I wouldn't recommend it. I'm not aware of anything actually in Arizona law, though, Nick, I don't know if you are, that says you have to announce what your vote is so everybody can hear your vote. Ultimately, the vote just needs to be made. Is it reasonable? Boy, if it's one of those like the officer position or something that's for some reason like confidential or something, and they don't want to see how you voted because of the board dynamic, but I wouldn't recommend it. But I'm not aware of anything in Arizona law that would prohibit it. Nick, are you?
I'm not either, and I'm trying to think of what that would look like if somebody were to make a claim about it, and I can't really visualize it right now. But I guess just to answer the question, I'm not aware of any requirements. Although you don't see it happen very often, I have to say.
I think the best argument, other than it's not reasonable, perhaps, could be, say you're on a Zoom meeting and you don't do it so people can see, and you say, because I've had some of these where they say, okay, Mark, we'll text all of our votes to you or something. Well, that's not really an open meeting in some ways, right? Because it's not transparent. People aren't seeing how the sausage is made or how the legislation is made, so to speak. So I think it should be done openly and vote, because again, you're elected like a representative form of democracy. We know how our Congress people vote, right? I think it should be done the same way, but I'm not aware of anything in Arizona law that says thou shall not do that. I'm not aware of anything. Any other questions pop up, Brett?
So just to be clear, if there's not a quorum of the board, it's not a meeting.
That's correct. That's one thing where we can be clear on and not ambiguous, and we don't have to say, well, it depends. I guess, well, okay. The only thing I guess it could depend on is if your governing documents had something that said, a quorum is 2 out of 5, okay? Or any meeting between at least 2 members is a board meeting. I don't know that I've ever seen that, but it's possible. But does Arizona law say that? No. And if Arizona law, if it's less than a quorum, that's not a board meeting. If you have 5-member board and Nick and I are on it, I can call them whenever I want to talk about board business. Is that transparent? Probably not. Is it violative of Arizona law? No.
What level of financial information can a homeowner require from the association?
Okay, it's basically, and we've litigated these cases too, this is a records request, okay? So say the homeowner says, you know what, I'm only seeing a balance sheet and an income statement. I want to see a statement of cash flows. And say, we don't have a statement of cash flows because we don't do a statement of cash flows. You don't need to produce it and do it just because an owner wants you to. If you have a balance sheet and income statement, though, and a statement of retained earnings, you need to provide that pursuant to 33-1805 in the Planned Communities Act. That's a financial record of the association. So long story short, if you have the record, you should produce it, unless it meets one of the criteria, like it's the personal, balance of somebody, or it has their social security number on it or something. But otherwise, you produce it if you have it. And if you don't have it, you don't need to create it. Anything to add on that, Nick?
No, I was gonna jump in and say, but not if it meets, if it concerns one of the topics and discussions of the executive session topics. But you covered it, so. And I will say that's one of the sort of gray areas of sometimes whether or not something meets the definition of a record, or whether or not it, it can be withheld, or how to withhold it. I mean, honestly, that's something that it'll be a case by case basis, and your manager will be able to guide you through that process. A lot of times they'll throw it to us and say, hey, they want this record, they made this request, given all these kind of considerations, what do we do with it? And then we can offer a legal opinion that you can rely upon and take it back and say, you're not getting this because on the advice of counsel, we're not turning it over. Again, goes back to that safe harbor discussion we had earlier. So, but again, that's this issue is just like most of these. A lot of them are going to keep coming up over and over, and there's going to be a lot of gray area. But like I said, there's always going to be somebody on your side to walk you through it and guide you to the right.
All right, next question. How much detail needs to be provided for items to be handled in executive session?
How much? Okay, so the statute changed a couple of years ago to really require us to tell homeowners what areas we're going to talk about in executive session. So you don't have to say, Nick and Mark are going to come and talk to us about the lawsuit that Mrs. Jones just filed. All you have to say is, we're going to meet to talk about the following issues or following topics. 33-1804 subsection A1, legal advice from an attorney, or A2 or A4. Don't just list them all just in case. I would say list the ones that you'll actually be talking about. That's a requirement now as of about 2 or 3 years ago. But you don't have to say anything more than that. Good question.
Are minutes made available to the public of an executive meeting?
No, absolutely not. And that's one of the things in the 33-1805 that you don't have to produce are minutes of an executive meeting. That is one thing Arizona law has made clear. Can you produce them if you want? Will somebody get them short of attorney-client privilege information if they subpoena them in a lawsuit? Probably, but you do not have to provide executive session minutes as in a request for records by a member. Absolutely not.
I have an HOA Gmail account. Is that sufficient to shield my personal Gmail account?
So if you have an HOA email account, is it sufficient to shield the personal Gmail account? It depends, but it may be. If you can show that all of my emails about HOA business are out of that particular HOA account and you testify that under oath, I think there's a pretty good argument when the plaintiff's attorney comes knocking, we're not producing your personal emails, okay? Could somebody get at them if they have reason to believe there's something in there? Perhaps. But if you're really good about only doing association business out of your HOA account, yeah, there's a really good argument that nobody should be poking around your personal accounts.
Which I would just jump in and say that if there were a piece of practical advice, it would be that everybody who's on this call should immediately make sure they have a specific email account that they use exclusively for HOA business. Because I have seen subpoenas for personal email accounts, and I've seen some information that people would not want shared with a bunch of lawyers and judges and juries. So I would just say if there were one piece of practical advice, go out there, set up an email account that you use exclusively for your association business, like now, like today.
Great advice, Nick.
Did I hear you say that the agenda does not need to go out with the meeting notice, but should be made available at the meeting?
Correct. Unless your governing documents require that the agenda go out prior to the meeting, Arizona law only requires that the agenda be made available at the meeting. So it could be put on your website 2 days before. It could be made available just as a copy. I mean, obviously with Zoom, you need to make it available in some way because there's not an in-person meeting, right? But it doesn't need to be made available a certain amount of time before the meeting unless your governing documents require.
Are there legal restrictions on amending the CCNRs to limit homeowner displays of flags or political postings?
Well, not technically, but practically, yes. So I believe it's 33-1808 because we've handled that a lot, haven't we, Nick? Flags lately, just a political season.
A lot, yes.
So 33-1808, you cannot trump 33-1808 by a CCNR amendment, okay? State law and federal law will always supersede your governing documents if it wants to. And how do we know if it wants to supersede? It will say notwithstanding what's in your governing documents. And that's what we have in 33-1808. So it doesn't matter if you amend your CCNRs to say you can't, put up the United States flag or the Gadsden flag or the state of Arizona flag. Doesn't matter. That statute's still going to supersede what you have in your governing documents. Now, if you don't, trounce all over the statute and you want to make other rules to say we're only going to allow the flags in 33-1808, you can absolutely do that, but you can't say that we're going to prohibit those flags.
And then the last one is, who controls board meeting agendas? Can any board member add an agenda topic? Can the manager decline to accept an agenda topic from a board member?
So here's what I would do. I mean, I would go through your processes, right? Like you normally do and say, this is how we set the agenda. The board president, fields topics from the board that goes to the manager, and then you set the agenda and send it out. Whatever you're using right now, if it's working, that's fine. But I would say I like at the start of a meeting, after you call to order, adopt the agenda before you even maybe talk about minutes. What do we want to talk about today, board? And if the board, meaning a majority of the board members there, say we want to talk about house painting today, add it to the agenda because that's the board's prerogative. Now, should you constantly be doing that so homeowners aren't aware of what you're going to talk about until the last minute? No. But by the same point, you shouldn't be hamstrung just because a topic came up yesterday that you need to talk about today and it didn't get on the agenda that you printed last week. Nick, anything to add on that?
No, I mean, I just want to reiterate your point that, the purpose of these meetings is for the board to conduct business. So yeah, if it comes up that, hey, this issue popped up yesterday, I'd like to discuss it, and the rest of the board is, is in agreement, then feel free to do it, because like I said, it's the idea here is that we're conducting the association business and making sure that we're doing what we need to do to keep the association running. So if that calls for some last minute agenda items, then, that's totally fine.
So that actually was not the question that got answered. So the question is, can any board member add an agenda topic if it's a week in advance of the meeting? So just to clarify, typically we tell our boards that, we like to have one point of contact, typically the board president, who sets the agenda with the manager.
Mm-hmm.
Yeah, I would say that's what we usually see that works the best. But again, and I'm sorry if I didn't answer that specifically, but I thought I did, because ultimately, if a board member wants to address it, they can bring it up at the meeting and have a vote to whether to put it on the agenda. So maybe if the question is, can anyone add it before? Well, not if that's not your policy. The board can also vote on the policy. Here's how we adopt our agendas. Follow that policy. So if your policy says no, the treasurer can't just add something to the agenda willy-nilly. It goes through the president to the manager to get on the agenda. I would follow that. And if the treasurer still wants to add something, they can bring it up at the board meeting to see if the rest of the board wants to talk about it. Any other questions coming through, Brett? These are some great ones.
That's all the questions that have come through. I guess the last question would be, do you guys mind if we make these slides available to the board members as a PDF?
No, absolutely. Please do. And if any board members have any questions, reach out to myself or Nick and just go through Brett. You can get our contact information, and we're happy to help.
Great. Thank you, guys.
Well, thank you. Thanks so much for having us tonight. There were a lot of attendees. This is amazing for a Wednesday night to listen to two guys talk about HOA law, but we enjoy doing it, and we'd love to help your associations if you need anything, and feel free to give us a call, and thanks for your time tonight.
Thank you.
Thanks, everyone.
Thanks, Brett. Have a great evening.
You too. I just wanted to remind our board members that are still on, our next board training session will be April 28th at 6 p.m. Going more in detail about open meeting laws and some other HOA statutes as well.